Stepping into an exam question involving the English legal system without a procedural map is like navigating a labyrinth blindfolded. Before you can argue the law, you have to know where you are standing. Consider our hypothetical client, Saul. He faces two distinct legal threats simultaneously. On one side, the state is charging him with the crime of robbery. On the other, a former client is suing him in a civil claim for £120,000 in professional negligence. Your objective is to map both of these tracks flawlessly. You need to identify the correct court of first instance, pinpoint exactly who makes the decisions, and map the precise route of appeal if things go wrong. To find the starting line for the civil track, we look at the financial value of the claim. The amount of money in dispute dictates the appropriate venue. For the criminal track, the filter is entirely different. Venue is determined by the severity category of the offense the state is charging. If a trial fails, the appellate system acts as a secondary filter governing both tracks. But this upper level has a strict entry requirement. It distinguishes rigorously between a dispute over what actually happened and a dispute over how the law was applied. The English legal system operates as a highly calibrated series of filters. Navigating these filters is the required first step before you write a single word analyzing substantive law. Let's isolate Saul's civil problem, a professional negligence claim valued at £120,000. To locate the correct court, we start with the Crime and Courts Act 2013, the statute that established a single county court. The statutory rule is clear. Civil disputes involving amounts up to £100,000 must commence in the county court. Claims exceeding that threshold gain the option to start in the High Court. This is conditional. The claimant must justify the choice based on high financial value, complexity, or general public importance. Saul's case hits both triggers. At £120,000, it clears the financial threshold, and a professional negligence dispute inherently involves complex expert evidence. This claim belongs in High Court. This flowchart illustrates the hierarchy of the courts. Look closely at the High Court section. It is internally divided into three distinct divisions: the Queen's Bench, the Chancery, and the Family Division. Stating the case goes to the High Court is incomplete. Professional negligence is a tort action. By jurisdictional design, contract and tort claims are allocated directly to the King's Bench Division. Here is an examiner's tip. If you advise a client to issue a tort claim generically in the High Court without specifying the division, you will lose marks for lacking procedural precision. Misidentifying the court of first instance reveals a failure to understand statutory financial thresholds. If your venue is wrong, your subsequent procedural advice collapses. We pivot now to the other side of Saul's problem, the criminal charge of robbery. Criminal procedure classifies offenses into three severity brackets: summary only, either way, and indictable only. Robbery is an indictable-only offense. The preliminary hearing occurs in the magistrate's court, but the case must be set upward for trial in the Crown Court. A trial on indictment in the Crown Court requires two distinct decision-makers operating simultaneously, a judge and a jury. In our scenario, Saul intends to plead not guilty. He claims he was at home watching television when the robbery occurred, an alibi defense. Whether Saul was actually on his couch or committing the robbery is a question of fact. Assessing witness credibility and determining the truth of that alibi falls exclusively to the jury. The judge, conversely, manages the law. They rule on the admissibility of evidence during the trial, and at the conclusion, they instruct the jury on the specific legal criteria required to convict. The jury delivers the verdict. The judge directs the legal framework and, in the event of a conviction, determines the sentence. Conflating the role of judge and jury breaks the logical architecture at a criminal trial. You must keep these functions strictly separated to analyze any grounds for an appeal accurately. Suppose Saul's alibi fails, the jury convicts him, and the civil trial also ends in a loss. He wants to appeal both outcomes. The immediate hurdle in both systems is that appealing is not an automatic right. The appellant requires formal permission from the court to proceed. Courts grant permission based on the nature of the complaint. Appeals targeting witness credibility represent factual disputes and rarely succeed. Conversely, appeals targeting judicial misdirection on legal definitions address points of law, the specific domain of the appellate system.
This diagram maps the civil appeal system. A decision originating in the High Court flows directly to the Civil Division of the Court of Appeal. This schematic details the criminal appellate route. From a trial on indictment in the Crown Court, a defendant appeals to the Criminal Division of the Court of Appeal. From there, the ultimate destination is the Supreme Court. Reaching that apex brings us to a major piece of constitutional legislation, the Constitutional Reform Act of 2005. Before this act, the highest court was the Appellate Committee of the House of Lords.
The 2005 legislation deliberately decoupled judicial power from the legislature, replacing the law lords with justices of the Supreme Court, who physically moved across Parliament Square into their own independent building. To see exactly what justifies a trip to the Supreme Court, we can apply an IRAC analysis to the landmark case of R. v. Woolen. The core issue was how to define indirect intent in a murder trial. The judge legally misdirected the jury on the standard for intent, a pure error of law regarding the defendant's a crime. The appellate courts intervened specifically to clarify the legal framework, leaving the witness testimony and jury deliberations undisturbed. Access to the Supreme Court requires you to state explicitly that the case involves a point of law of general public importance. Appellate courts function as specialized mechanisms for developing the common law and correcting judicial misapplications. Here is the complete structure of the senior courts. Saul's civil negligence claim anchors in the High Court, traveling upward to the Civil Division. Simultaneously, his robbery charge begins in the Magistrates' Court, elevates to the Crown Court, and routes to the Criminal Division. Jurisdiction is a mechanical filter. It sorts first-instance cases by their financial value or offense severity. The appellate level then sorts those outcomes by separating factual disputes from pure legal errors. Thanks to the Constitutional Reform Act of 2005, this entire hierarchy caps off with a Supreme Court that operates independently of Parliament, ensuring the transparent administration of justice. Before you attempt to write a substantive answer about tort law or criminal liability, force the facts of the exam question through this precise mental flowchart. Find the correct starting block. Professional mastery of the English legal system depends on identifying the precise procedural forces that transform a localized dispute into binding national precedent.